Hello, I'm Jo Rogers. I'm a lawyer and I'm the founder of Navistar Legal. Welcome back to this series in which we are looking at entering into agreements with businesses that are much bigger than you. In our last video, we looked at the due diligence process, so the preparation before negotiation, and how to check up on the company that you're about to deal with. In this video, we'll focus on understanding the risk profile of the agreement. So next, let's consider some basic principles before you get into negotiations. Number one, it is definitely worth keeping a note of all conversations, whether it's in person or on the phone, and do it in a format that's accessible for reference later on. In the event there's a disagreement later on or terms seem to change, then you can refer back to your notes. Sometimes in larger businesses, don't be surprised if personnel move from departments often, and so miscommunication is possible and often likely. Number two, as a matter of good project management, follow up on telephone calls and conversations with details of your understanding of actions and minutes of the call. Do it in a friendly format by email, but this does allow gaps to be picked up early on and gives you the evidence in court in the event that something does go wrong. Number three, make sure that you keep negotiations subject to contract. Nowadays, we often discuss and negotiate deals through our email. From a legal perspective, this has the benefit of providing a paper trail. But if you're not careful, you may inadvertently enter into a legally binding agreement without giving it too much consideration. When you start getting into the details of a deal, then you should probably address an email subject to contract. That means that those discussions will only become legally binding once there is a signature of a formal written agreement. It also means that you don't intend to create a legally binding obligation until that formal agreement has been entered into. But remember that the opposite is true if it is to your benefit to have these terms agreed in email. It could be tempting to start performing services prior to formalizing a formal agreement. Many people do it. You would not be in the minority. But do be aware that if you do that, you do take the risk that the other party is not bound by the terms you think you've agreed to, and so you might not be able to enforce those terms later on. Now let's look at how you might calculate what I would call the risk profile of any relationship. Taking risks that others take is actually a way of getting beyond the competition, if those risks are smart. Any decisions that you make should be based on your own appetite for risk. Taking the wrong risks, you know, is a recipe for disaster. Most successful business owners take a very balanced view based on the calculation of their risk against their own risk profile. That's what we're going to do today. It means they use a mixture of their common sense, their own values, their understanding of certain terms, and their own experiences to weigh up the agreement itself. We'll start with some basic maths, a basic formula that I use to understand the risk of any agreement. So write this down. The potential costs, or the liability, multiplied by the likelihood of those costs, equals the risk profile of the agreement. The risk profile is a number from 1 to 16. 16 is the highest risk, and 1 being, you guessed it, the lowest. So let me explain how this calculation breaks down in practice. The potential costs are basically an estimate of all of the costs that might be incurred if the agreement came to an end today. You can add up any financial costs, including lawyer fees, fines, or penalties, as well as the cost of someone's time to deal with the issues or to repair your reputation. Think of a contract in your business. How much potential loss is there? Would you lose your reputation? How much time would it cost in dealing with it? Would you have to pay any fines to that other party if you did something wrong? Would you have to provide a refund to them? Would you have to get a lawyer involved? And what estimated costs are you likely to incur as a result? Rate this damage to the business if you had to pay this amount immediately today. Rate it on 1 if the damage would be a low risk, and rate it 4 if it would be totally devastating to your business. Write this number down as your potential costs number and keep it until the next part of the equation. You will notice that the rating is always going to be proportionate depending on the size of your company. A low-risk agreement for one company will not be the same as another. A cost of, say, £100 may not cause the loss of any additional clients, and it would require a minimal amount of time to deal with it. But a devastating risk agreement may cost the company £100,000 or have another serious effect, such as an insolvency or criminal penalties. The smaller the company, the more of a problem a, say, £10,000 loss would be. To a larger business, it could swallow it up, it might be irritating, but to a smaller company, it would be devastating. Now we're going to look at the likelihood that an agreement will come to an end. This is also rated on a scale from 1, unlikely to end, to 4, may imminently come to an end. You may want to base this on your current relationship. If it is new, then it's more likely to terminate. If it's been in place for years, perhaps it is less likely to end soon. 4 is it could end at any time, and 1 is it will be in place for years to come. If there are issues within the relationship, then it's probably closer to 4. Write down the number that comes up for you and put this down as your likelihood number. Now let's take both of these numbers and multiply them together to get the total risk profile of your contract. Clearly, if the agreement you worked on is rated 16, then it will have a high impact on your business. Therefore, the contract must be on your radar, certainly more than an agreement that's rated as a 1. If you haven't signed the agreement already, then you can now focus on bringing these two numbers down. Higher risk agreements that would cause devastating loss will definitely need to be monitored, certainly more often, and you'll want to have a system in place to make sure that any complaint or any dispute is handled immediately. Now, only you know your appetite for risk in your own business. You may be okay with an 8, others would reduce it to a 4, others might want it to be a 1. Having an awareness of the risks and how to mitigate certain risks will cost you money, either by way of insurance or a well-drafted agreement or paying for legal advice. So if you already have some contracts in place in your business, you may want to download our contract register from our website. And you can start working through the process of working out what the risk profile is for each agreement. Certainly when you're getting ready to start a negotiation with a larger business, just know that there aren't going to be a lot of changes that you'll be able to make. The aim of your negotiation will be to reduce the potential losses and the likelihood that will occur if something goes wrong. You will certainly never eliminate all the risks in business, but this is a good start to understand what those risks are and how that might be supported in your business. It is likely that over time, experience will be your master, but I hope that you can pick up some good ideas in the rest of this series. And that brings us to the end of our video around pre-contractual preparation for your contracts. I look forward to you joining me in our next video, where we'll dive into the clauses that you should definitely exclude or definitely include when dealing with larger businesses. Thank you for watching.